There we go. Okay, so start off this morning with a disclaimer, of course, as me being an attorney. We've got to remind you all that this does not constitute legal advice. It does not create an attorney-client relationship, but you can always call me with your questions, and I'm happy to talk to you at any time about your legal issue related to real estate or business. A little bit about me and my firm. We were founded in 2007, but I've been an attorney since 2003. My office focuses on real estate and business law. We do litigate, so deposit disputes, landlord, tenant, all those things that you might think of for a real estate firm, we handle. I am chairman of the NABOR Legal Resources Committee this year, and I serve on the reptile section of the bar's Real Estate Industry Liaison Committee. So you can always call me with your contract questions. I know the contracts, FAR, BAR, and NABOR very well, and am happy to talk you through any issues that come up. Today, we're going to talk about the title process, a little bit about what's going on in the background, what the title attorney does. We're going to talk about taking a listing, and then we're going to go from contract to closing, what you need to do to get to closing, which of course is where we all get paid. I want to start off, I want to give you a couple of details about the title process so that you can understand what's going on. So you send over a contract to my office. The first thing we do is we start the title search, and that's researching the title. We look through the abstract, that's the old title documents, the history of the property, and we examine title. Our job, of course, is to clear claims and liens so the buyer gets marketable title. Up next, we order the survey right away. This takes a little while to get these days, but we want to make sure we know where the property is. So we always encourage our buyers to get a survey, or at least review the seller's survey. So we're looking for any potential problems, encroachments, and things like that. And then, of course, we make sure the property taxes are paid. We make sure the utilities and the HOA dues are current. And then we have the title insurance policy that we're preparing, and that is a insurance policy that says if there's not marketable title, of course, then the buyer has a claim. Up next, we're looking at the loan documents, of course, make sure everything matches, the deed, the mortgage, the note, that 150-page package that the buyer's got to sign. We go through all that and make sure that it's organized and ready to go. And then, of course, we conduct the closing and we sign everything. I usually sit with the customers whenever I can, the clients, and make sure that they understand what they're signing. And then, of course, we disperse all the money, pay the realtor, pay off the mortgages, and do everything that needs to be done financially. And then we get the loan documents back to the lender. And finally, we record everything and we make sure that all of the liens have been released, that the deed and mortgage are properly recorded. And we take care of all of this stuff in the background so that you don't have to worry about it. But I do want you to know what's going on and what we're doing for you. And you say, what actually does the title attorney do for you as the realtor? Well, once the contract is signed, we handle the rest. We manage the deadlines. We negotiate inspections where needed. If you need help with that, we work on the loan. Sometimes there's short sales or anything else that needs to be dealt with in the closing. We help negotiate any extensions that needed. And then, of course, we conduct the closing. And all the while in the background, again, we're clearing title, pulling all the documents together, getting all the liens taken care of. And, once the contract is executed, we just begin the title process. And our job is to coordinate all the interests of the parties, the lenders, the buyers, the sellers, the real estate agents, the inspections, again, the survey, everything. And our job really can be summarized as making sure that the requirements for settlement are fully satisfied. And what we're really doing in the background the whole time is we're looking out for the red flags. And you might say to yourself, what are the red flags? Well, let's go over a few of them. So you're going to have people who are getting divorced, who are separated. You're going to have bankruptcies. You're going to have people who are in foreclosure. You could have recent marriages of the buyer and seller, and that's going to necessitate other parties to sign documents that maybe hadn't planned on it. We're looking for the liens and judgments against the properties, and all these things are available in the public record. Easy to locate on the clerk of court's website in your county. And we're looking for easements. Those would be recorded. Other red flags we're looking for, again, known encroachments. If the buyer or seller will not be present for closing, particularly the seller these days, that's an indication of fraud. You know, if there's going to be a power of attorney involved, we have to deal with that. And we'll talk about powers of attorney, trust, probate in detail in a few minutes. If you have a foreign seller, then we've got to deal with the FERPTA implications. And that means that we're comparing the 8288 and the 8288 forms, or if the seller is going to do a withholding certificate, that we get them with the CPA that can do that. If there's a guardianship or incompetent seller, then we deal with that, work with the guardian to get through the court process to get the property sold. And then, of course, we're looking for association liens that are filed against the property. One thing, though, I do want to mention about my office, you know, in my office, you're going to get looking for issues that are going to delay your closing, but you're also going to get us working to resolve the closings. And the issue is, you know, we want the closing to keep going. If you, any title agent or attorney can come to you and say, hey, we got a problem, we're not going to close. But in my experience in 15 years of doing this, every problem is resolvable. It may just take a little bit of time. And so you're going to get a solution from me. So let's talk about taking a listing and what you can do to make the process go more smoothly. Number one, these are just some tips that I've put together over the years. You know, before you even go on the listing appointment, you've got to review the prior deed. And you can find that in MLS or on the property appraiser's website is the easiest way to find it. There should be a link. And this is going to tell you who you need to deal with in the property. And if there are multiple people on the deed, you're going to need multiple people on your listing agreement, on your contract, and on the deed out. So you've got to be cautious about knowing who you're dealing with. To do that, you've got to glance at the public record. You've got a number of websites you can look at, the clerk's website, the county appraiser, and the tax collector. Some of the things that you're looking for, things like ex-spouses who were prior in title, if someone has passed away, is there an LLC owner? Is there a trust? Is there a power of attorney that was used to sign the prior deed? You may be dealing with an incompetent person. And number one thing now you have to look out for, unfortunately, is the fraudulent seller. And we're going to talk a little bit about that, but basically, if you've got a vacant land listing and you've not met the seller and there's no mortgage, unfortunately these days, Lehigh, Cape Coral, even Golden Gate Estates, you may be dealing with a fraudulent seller. You've got to get them on the phone, on the FaceTime or Zoom, and talk to your seller and make sure that you're dealing with the right person. And then one last little practice tip that I always like, before you even go on the listing appointment, if you've reviewed the public record and understand who you're going to be meeting with, pre-fill and pre-deliver the listing documents and the disclosures so that the seller knows what you're going to be dealing with when you go in to talk to them. I just think you look really professional. I've talked to some listing agents about this, and just as a great practice tip for everyone to use. So let's talk about taking the listing and what you need to deal with. Particularly, like I said, the number one thing these days is fraud. I hate that we have to deal with it, but we do. It's vacant land, no mortgage, foreign owner or an absentee owner. If the seller is not willing to talk by phone and they want everything by email, look for misspelled words and bad formatting in emails. If it's cut and paste looking, you're probably dealing with a fraudster. It's so bad and so prevalent these days that that's just the way it is. How do you prevent fraud and dealing with a fraudulent seller? Because think about it, if you spend all this money and you market a property and then we catch that they've got a phony passport at closing, I mean, you've wasted so much time. So number one, do a Zoom call, a FaceTime, something, see their face, look at their ID. The best, of course, is to meet in person and check their ID in person. But understand who you're dealing with. And the easiest way to deal with that, by the way, Google everything. Their name, their email address, their phone number, if they give you a phone number, just look them up and see what pops, because there are other people in other states where these fraudsters are operating, and they're posting, I spoke to so-and-so at this email address and they're a fraud. There are websites that look at this now as kind of a countermeasure. So just Google everything. When you're at the listing appointment, talk to you're talking to the seller. You're going to want to talk to them about, you've gotten the listing, they're going with you, you're excited, and everyone's ready to get this property sold. What are you talking about? What is the next step, really? And the next step is to get all the documents that you're going to need organized so that you can have a smooth closing. Ask them for their prior title policy. This solves a lot of title issues that delay closing. Ask them for their survey, for their mortgage statements. Ask them if they've got a second mortgage. A lot of people don't know that their lines of credit, their HELOCs are actually second mortgages. So you've got to ask that question a number of different ways. Did you get a line of credit? Did you get a HELOC? Is there a second mortgage? If they say yes to any of those, then you'll want to get those mortgage statements as well. Next thing you're going to want to do is get the association information. Just ask them for a copy of their statement and put that in your file so you can deliver it to your favorite closing agent. Who do they pay and how much and how often are the questions we're looking for. And then, of course, is there a master and a local association? We need to make sure that we get all of the association information. And then finally, with regard to associations, get the association documents. If you're selling a condominium, you know the rule. They have 3 days to rescind the contract up until you deliver the association documents, the 6 required documents for the association. So make sure you get those. And then, of course, what we're going to talk about in a few minutes, you're going to want to get any power of attorney, death certificate, trust agreement, LLC operating agreement. At least be prepared and counsel your seller that they're going to have to produce originals of these documents so that we can conduct the closing. Finally, of course, ask for any leases that they may have on investment property, if the property is currently leased, or if it's an Airbnb or a VRBO, Verbo, you want to see any leases that are in place. So before I move on to who signs the contracts, does anybody have any questions? Okay, and if you do have questions, you can always put them in the chat or just unmute yourself and ask your question. So let's talk about who signs for who. What do you need on your contract for an effective listing and sale agreement? Number one, LLC sellers, foreign corporations, international and domestic, you've got to record articles of incorporation and all their amendments. LLCs, you really only need 2 documents. You need the articles of organization, which are a public record, and we can pull those off of the Secretary of State's website where the property is incorporated. Usually, sometimes we have to order them. The other and more important document is the operating agreement. The operating agreement is the document that tells us who signs for the LLC. This is a very important agreement. If it does not exist, we can always go back to the articles of organization, but the operating agreement is the operating document. So one thing about LLCs that you need to know, there are 2 kinds of LLCs. There are manager managed and there are member managed. In a manager-managed LLC, the managers sign for the LLC and bind the LLC for the listing and for the sale. In the member-managed LLC, all of the members typically sign, and that's all the members. So if you've got 4 or 5 people in your LLC, you're going to want 4 or 5 people on your listing agreement and 4 or 5 people on your contract, and I'm going to put 4 or 5 people on your deed. You're always looking for who has the power to bind the LLC. And one other tip about Florida, there's no such thing as a managing member anymore. Any LLC where the members say they're managing members are now just member managed. There's no longer, you don't appoint one member to be a managing member like you used to back pre-2014. So all those managing members are just members now, and they all have to sign. So you may be in a situation where it used to be one guy says, yeah, I signed for the LLC, I'm the managing member. Now all the members are going to have to sign. So be very careful about that. The other thing is, if you don't have an operating agreement, we can look to the articles and see what they say. But if it's unclear, which most articles are, plan to have everybody to sign the LLC. So you'll want to talk to your listing person that's going to be doing the listing and say, your seller, and say, who else is involved in this company? And then you're going to talk to those people as well to make sure you get everybody on there. Because again, the whole purpose is to get everybody who needs to sign the deed on the listing and on the contract so that you can get paid your commission. And one other tip about LLCs, you do not have to register the LLC to transact business in Florida. I get that question a lot. To sue somebody in the name of an LLC, you do have to be registered in Florida, but to sell real estate, you do not. Questions about LLCs? Okay, and again, if you have any questions, just type them in the chat or unmute yourself. Let's talk about trustees. Trustees, it's very common to believe that trusts hold title to real property in Florida. Trusts do not hold title to real property in Florida. Trustees hold title to real property for the beneficiaries. And again, you're looking for who has the power to sign for the trust. So you may be looking for a successor trustee. You may need a co-trustee. So when you're looking at your prior deed, see who signed for the trust originally. If that person is still around, and if the trust powers are in the deed, then we may not need to deal with the trust agreement at all. But I can tell you in 99.9% of the cases, the seller's attorney must examine the entire trust document to get a clear title taken care of. Okay. Let's talk about when parties are getting divorced or when they're divorcing, when they are in fact already divorced. If your parties are divorced, that is, they are fully and completely divorced, there's a final judgment of divorce in one of the state courts, we still need to examine the marital settlement agreement, and we still may need an affidavit or a quitclaim deed to complete the marital settlement agreement requirements. For some reason, I don't know why, divorce attorneys always forget to do the quitclaim deed and transfer title to the final holder of the property, whichever spouse wins it in the divorce. So we often have to go back to the other spouse and say, listen, you didn't complete your marital settlement agreement requirements. You need to sign this deed. They get very upset. They demand money. They want to have a big fight. And we have to calm them down and get them to sign the deed, transferring title to their former spouse. We get it done pretty much every time without a problem. And I've only had to go to court, to divorce court once, thank goodness. If your parties are divorcing, then the other spouse is going to be signing for the homestead or marital property in almost every case. And remember that Florida does not recognize separations. So you're either married or not married. There's no well, we've been separated for 20 years. I haven't spoken to him and I don't know where he is. And I want to sell this property and he's on title. You got to find him. You got to get him signed. And so you're going to want to have me help you with that from the beginning when you take your listing. And again, you're either married or not married. So what happens when there is a dead person in the title? What happens? You go into the listing appointment and you're walking around, you're viewing the property, and you're with one of the parties to the deed, because you looked at the prior deed, you saw it was Mr. and Mrs. Smith, and only Mrs. Smith is there. And you're gonna have to ask, is Mr. Smith available? And of course, he's passed away. If the title was in both of their names, that's great, no probate. If title was in one name, then you need a probate. If both parties to the deed have passed away, you probably need a probate. Even if the property is in trust, because there's some bad case law in Florida for trusts, if you're trying to say disinherit a spouse to the children of a former marriage or something like that, which was the Aronson case, even if the property was in trust, you probably still need all the beneficiaries to sign, because you cannot disinherit a spouse and minor children in Florida when you're trying to alienate homestead property. Okay, questions about any of that so far? Trusts, deceased persons, divorces? Seeing none. Okay, let's keep moving. So what do you do when you have a power of attorney? Number one, you've got to comply with Florida law. That seems crazy to have to say that out loud, but the law changed in October of 2011, and now you need to comply with the formalities of the deed, which means 2 witnesses and a notary. If the POA is from a different state, however, we may just need an opinion letter as to the validity of the letter of the POA in that state from an attorney in that state. If the power of attorney states that it is a durable power of attorney, then if the seller is incapacitated, we can still use the power of attorney. The agent signs for the principal, the seller, and all is good. We record the original power of attorney for closing. I can't emphasize that enough. We record the original. We must have the original power of attorney. The seller will get it back. We will walk it into the clerk of court's office, but you must have an original power of attorney for closing. Now, normally, if a power of attorney is not in existence when previously, we're probably not going to want to do a power of attorney in most cases, because the seller has to sign the power of attorney with the formalities of the deed, 2 witnesses and a notary. So it's just as easy to have them sign the deed as it is to sign a power of attorney. In a dire situation, multiple parties, we're not ready to close, but we got to get people are going to be leaving town, we may use a power of attorney, and we'll get those drafted and get those out to the parties very quickly. Okay, before I go from contract to closing, let's see if we have any questions. Lance is asking. Lance, you're asking about why provide your prior policy. That's a great question. The title insurance policy from the seller shows that the seller had marketable title when they purchased. It becomes what we call base title, and we start with that document and the date of that document, and we're only looking for documents in the public record after that that would encumber the current seller's title. That's what the prior policy is for. It used to be in the NABOR contract that there was a $150 penalty for failing to provide that. We have since removed that as a legal resources committee because it just seemed punitive and it was frustrating to a lot of folks. But the contract, both the FAR bar and the NABOR contract, say that you will provide the prior policy if it's in your possession. So moving right along. what can the realtor do to make the closing go smoothly? What can you do? You've got your listing, you've got the contract is signed, the deadlines are ticking. We got to move quickly to get everything taken care of. What can you do? Get the closing package to the closing agent right away. Don't delay. The day the contract is signed, get all the contract pages, all the documents listed here, which we've already gone over, including your commission information, to the closing agent right away. You know, you've got to put everything in there. I know it's crazy, but the association information, the name of the association, the contact people, you know, get the application to the buyer. The contracts say that the seller shall provide the application to the association. FAR specifically says seller shall initiate the approval process. The original power of attorney and the original death certificate, we need originals. And we can order death certificates if we need them. And then we have these comprehensive information forms that we'll provide that will really help your clients get everything together. So if you go to my website, sodlegal.com or paradisecoasttitle.com, you can get the comprehensive information forms and review them with your customer, because we're going to be sending them out to the seller and the buyer and collect all their information. So it's kind of a final point. You know, your closing agent is a resource for you. If you have a question, you can call me anytime, 24 hours a day, 7 days a week, and we will help you navigate the red flags for closing. I don't know why my flag is blue on this slide, but it should be a red flag for closing. Okay. You know, the banks want more information now. So what do we need from you? We need your information, your buyer and seller information. And if you tell me about your deal early, if you call me when you get the listing, I can even start the process sooner, and every legal issue can be solved with time. We can do it. One more thing to think about: what should you demand from your closing agent? Well, I think the most important thing is accuracy, timeliness, and information. You want your closing done right and done right away. And you want to know, a question you can always test your title agent on is, when do they order the title commitment? If they don't order it first thing, they're doing it wrong, because having that title commitment document in hand early will help us solve a lot of problems. But you should also be getting information about the closing. Any early notification of issues should come up. It's working together is a big deal in this process. And with that, I will take questions. Looks like Leanne has a question. You mentioned earlier that there is a deceased spouse and both names are on the deed. The no probate is necessary. Is that correct? No, Leanne, that is not correct. If there is a deceased spouse on the deed and one of the spouses is deceased and it's held as a joint tenancy, then you can avoid the probate. That's the typical case for husband and wife, or for joint tenants. If they're, you know, it can be brother, sister, or whatever it is. If it says joint tenants with rights of survivorship, or if it says husband and wife, or tenancy by the entireties, and one of the persons has passed away, then the other person takes title automatically when the death certificate is filed. But if both have passed away, I think is what I said, then you definitely need a probate. Other questions? Put them in the chat or unmute yourself. Anybody? Lance, you have a question about revocable trusts? Go ahead. Any other questions? Oh, if someone has passed away and they were the trustee, that's a great question. So if one of the trustees has passed away, then we have to examine the entire trust agreement and figure out who the successor trustees are. So what happens is you look at the prior deed, you see it says Bob Smith, trustee of the Bob Smith Revocable Family Trust, and Bob Smith has passed away. In the trust agreement that Bob signed when he created the trust, there will be a successor trustee provision, we hope, and he will name somebody to take over the trust once he passes away and distribute his assets. So it's really kind of a quirk in the law, but it's important. When you look at the prior deed, if it says Bob Smith, trustee of the trust, and Bob Smith is the person you're talking to on the listing agreement, and the deed into trust contains the trust powers in section 780, I think it's 3. Let me go back to that slide. Apologize. Trust 689.073. If this language here is in the deed to the trust, and you're talking to the current trustee, you do not need to examine the entire trust document. It's only when there's a successor trustee or someone who's going to sign who's not named in the prior deed. What I'll tell you about trusts are, if you've taken a listing and you want, and there's a trustee involved, go on your listing appointment, get a copy of the trust agreement, and then call me right away. We'll take a quick look at it, and we'll make sure that you're dealing with the right person so that you're not wasting your time. And then, and by the way, I don't charge to do stuff like that. So just email it to me and I'll take care of it. Other questions? All right, everybody, I really appreciate you coming in today. Thank you very much for your time. If you have questions or concerns, you can always reach out to me on my cell, 239-784-5556, or email me and I'll get right back to you. Thank you again, and we will talk again soon.